Welcome to Law Sessions. I am Jennifer Housen. In this law session on public law, we will explore the concept of royal prerogative. Now, you will of course have seen the other law sessions in relation to, for example, separation of powers. You would have seen, for example, parliamentary sovereignty. And what we're exploring here are certain powers described as royal prerogative, and we will go into it somewhat to understand what the royal prerogative it is and what it allows for. Now, as a starting point, the royal prerogative is described as being the inherent legal attributes which are unique to the crown. Now, the prerogative primarily consists of powers, some of which are exercised by the monarch in person, so example, appointing ministers and dissolving parliament, but many more are exercised on the monarch's behalf by ministers and by civil servants. And these, of course, would include such things as the granting of pardons and the management of the UK's external relations. Now, royal prerogatives include things like immunities. So, immunities relating to income tax, for example, or privileges. Now, there are some archaic prerogative powers. For example, the crown's right over swans and certain types of fish. And there are, of course, prerogatives in respect to duties, for example, to provide diplomatic protection to subjects in a foreign country. Well, with the exception of honors in the personal gift of the sovereign, things like membership of the Order of the Garter and the Royal Victorian Order, convention lays down that the sovereign shall only exercise certain of his or her personal prerogative powers on the advice of her ministers and in accordance with that advice. This, of course, is a convention, and certainly we will look at convention in a later law session, in fact, the law session immediately after this law session. But it is by convention that the monarch does act on the advice of ministers. Of course, the monarch could disregard that advice. So the monarch could legally effectively act against or without ministerial advice. But unless the circumstances were rather extremely unusual, this would, of course, probably lead to a statutory curtailment whereby Parliament would make an act of statute. So when you look at prerogative powers, and again we will explore that further, it really is a situation where Parliament could curtail a prerogative power by passing an act of Parliament. So an example, of course, is where such an action may be acceptable would be, for example, dismissal of a government refusing to resign or request a dissolution after losing a vote of no confidence. If you get to a situation like that where, for example, the Crown had to intervene or didn't intervene, it may very well be that an Act of Parliament would have to, of course, come on board. Now, the whole idea of prerogative powers has largely been a rather mysterious state of affairs. And until recently, nobody really knew exactly what they were. They might have some idea what one might be and the like, but it was all pretty much shrouded in mystery, with a subsequent request, or a recent request rather, for them to be revealed. As I say, generally, they're not said what they are, but recently, and when I talk about recent, we're looking at about 2003, we see that there was this push for greater accountability, greater transparency, and in 2003, what we saw was a list being published when the Commons Public Administration Committee managed to obtain the information from the DCA, the Department of Constitutional Affairs. Well, in October of 2003, what we had was these prerogative powers, these powers wielded by the government. And again, remember, when we talk about the government legally, we're talking about the executive, we're talking about the Prime Minister and his or her cabinet. Well, until October 2003, the powers that the government used in the name of the monarchy were set down on paper for the first time, and what we saw was this mysterious veil being lifted as it related to royal prerogative powers. And in effect, a list of them was published in order for there to be this far more open, transparent society. Well, the prerogative is handed from monarchs to ministers, and what it allows them to do is to take action without the backing of parliament. And the idea is that when you look at the government, Her Majesty's government, the executive is there to, of course, move along policy lines, and there are decisions that they can take which has nothing to do with parliament. So I might vote for my MP, but something that affects me or any other citizen may have actually been a move carried out by the executive. Certainly, when one looks at the Iraq War, which is something we will come back to later, that is something that was more or less decided by the government, not parliament, and what we see is prerogative powers coming to the fore in that happening. Now, as I say, with this greater accountability and the publishing of the list, one of the sorts of things that are included that we see on the list are that the powers include those that allow governments, for example, to regulate the civil service, the issuance of a passport. Just because you're a British citizen, a passport is not as of right. It is a prerogative power. Now, the ability to make treaties, to appoint and remove ministers and grant honors are prerogative powers. The prerogative of mercy, which is no longer used to save condemned men, of course, from the scaffold, but it's still relevant because it can be exercised to remedy miscarriages of justice, which are then not put right by the court. You can exercise prerogative powers to fix that. So in its the paper, the government said that new prerogative powers could not be invented, and that most of them, well, quite a few anyway, have fallen out of use altogether. And frankly, it might be that it's gone forever. Now, you have to look at some of these prerogative powers contextually in the time that they were being used. So you may have had a prerogative power, say, in the 17th century, 18th century, which, as we come in this 21st century, is completely irrelevant. So, for example, the prerogative power to press men into the Navy. So that is no longer, as it were, in use. But it is said that there were still significant aspects of domestic affairs which the powers could still be used despite any kind of legislation. And it is also accepted that the conduct of foreign affairs remained very reliant on the exercise of prerogative powers, and that they can still, to some extent, adapt to changed circumstances. And that is true, because you may have a prerogative power which in its raw form provides for something, but when you look at a specific situation, and I'm actually thinking here of the case where the prerogative power of the defense of the realm allowed a police authority to be issued with baton rounds or rubber bullets, as it were, and they use the prerogative power of defense of the realm to allow that sort of situation. So even though you cannot create new prerogative powers, by and large, you may be able to adapt the circumstances. Now, although it hasn't been possible to give a comprehensive catalog of prerogative powers, you are able to still see from a list of what these prerogative powers are. Now, as I say, you can identify prerogative powers which previously were not necessarily recognized. And as I said, even though it may fall out of use or hadn't been used a long time, you may still, for example, be able to use it. And going back to the case that I talked about, the baton round, the case, of course, is the ex parte Northumberland police force case. And the court in that case said that the Home Secretary had power to issue these baton rounds to a chief constable without the consent of the police authority, because the court said that the crown had a prerogative power to keep the peace within the realm, to defend the peace, as it were. And the idea here is that when you looked at that case, the issue in Ex parte Northumberland Police was whether or not a police chief, and in England and Wales, police authorities are separate. So, for example, in London, you might have the police authority there. In Yorkshire, you have a police authority there, and so on. And they tend to be fairly autonomous. The West Midlands has its own police force. But within all of this, you have the Association of Chief Police Officers. And the issue was whether or not we have a police authority who, if they did not get, for example, the agreement of the Association of Chief Police Officers, could the Home Secretary, through the police, issue baton rounds, prerogative powers, of course, which does not rely on anything else but from its own power, as it were. Yes, prerogative powers could be used. Well, when you look at prerogative powers, they fall into two categories. They fall into domestic affairs, they fall into foreign affairs. Now, based on the list and what we see from that, if we were to consider what are the prerogative powers which fall into domestic affairs, well, we see things like the appointment and the dismissal of ministers, the summoning, the prorogation, the dissolution of parliament being prerogative powers. The royal assent to bills is a prerogative power. The appointment and regulation of the civil service, the commissioning of officers in the armed forces, directing the disposition of the armed forces in the UK, the appointment of Queen's Counsel, the issue and withdrawal of passports, the prerogative of mercy, as we mentioned before, the granting of honours, and certainly the creating of corporations by charter. When you look at issues relating to foreign affairs, the sort of things we see are the making of treaties, the declaration of war, the deployment of the armed forces overseas, and also recognizing foreign states. Equally, it looks at accrediting and receiving diplomats. Now, those are the areas that we see prerogative powers being exercised, or what falls under prerogative powers based on the list. But if you were asked, what are royal prerogatives? What are prerogative powers? Well, in a nutshell, the point would be that it is a series of historic powers officially held by the monarch that have in reality been passed to politicians, namely, of course, the government, the cabinet with the prime minister. And they enable decisions to be taken without the backing of, or indeed in consultation with Parliament. Now, the royal prerogative is the term given, as I say, to the formal powers of the Crown within the executive process of British politics. And what you see in relation to the royal prerogatives are powers which are indeed part of the common law. We're going to take a short break, and when I return, we will carry on by looking at the substance of the royal prerogative, and we will also explore some of the common law issues, and certainly we will look at some of the cases in this regard immediately after this break.